There, Appendix 1 to my paper has a substantial body of law that upholds the proposition that you apply state law to insurance on the risk. When I first started making these presentations, this body of law was pretty small, and it's gotten bigger. There is an opposing point of view. There is a minority view, and it makes me uncomfortable to even say it, but here's what some courts say. Some courts say that a self-funded plan does not lose its status as a self-funded plan simply because it has some insurance. Now, that's not a prevalent view today, but there is a body of law out there that says that. So there have been some federal courts that will tolerate the idea that this $10,000 gorilla can stand behind a $250 deductible and pretend that there's no insurance there. The same thing is going on. We've had a lot of successes in applying state law to insurance on the risk. If you ask the question, how do you determine if there's insurance on the risk, I've got 5 answers for you on pages 19 and 20. I'm not going to take the time to go over those answers now. It's not an easy question. Like I say, as much as we want that information, they do everything they can to hide that information and to characterize it as something other than it is. But it helps to be knowledgeable in what documents have to be filed by these plans. I have this assistant who used to file these documents, prepare them and file them for the plans, and so that's helped me. And so if I do get involved in cases. The vast majority of cases I do are pro bono. I do get involved for hire. I work either on an hourly contract rate or on a contingency basis for cases that merit that. But I do pro bono work on just about any file that I get contacted on and am available to answer questions. Let's talk about these 3 U.S. Supreme Court decisions quickly. My page numbering is 21. It might not be there. I want to talk about the Albarn case. This is a Medicaid case. It's not an ERISA case. But this was handed down 2 weeks before the Sereboff decision. This case arose in Arkansas. The Medicaid had paid $215,000. The tort recovery was $550,000, and Medicaid in the state of Arkansas wanted all of the $250,000. They wanted this first dollar priority. They wanted all the $215,000. The trial court gave Medicaid all the $215,000. The Albarn's attorney said, look, and got the other side to agree, our total damages exceed $3 million. She had brain damage. Our total is a young girl in college. She had over $3 million in damage. We only collected 1/6 of the total damages. So we should only have to pay back 1/6 of the medical bills. Now that was the argument. And the 8th Circuit bought that, and the Supreme Court affirmed it in a unanimous decision authored by Justice Stevens. And that's what's called pro rata loss sharing or equitable apportionment. If you only collect 10% of the total damages, you should only have to pay 10% of the medical bills. If you only collect 1/3 of the total damages, you should only have to pay back 1/3 of the medical bills. New Mexico follows that as equitable apportionment. Other places follow it pro rata loss sharing. Now, Justice Stevens, we didn't know it at the time when we were in the Supreme Court in the Sereboff case having that oral argument, but he was authoring this decision in Albarn. And in the oral argument in Sereboff, he grilled the plan attorney on this principle. And it was clearly his position. I used to quote his transcript here, but you can find it in the transcript. It's public record. He clearly made it known as his views in the oral argument that this same thing should apply in ERISA, that would be equitable. But once again, in the ERISA case, or in the Sereboff case, there was lots of money to go around, and so they paid back the $75,000. The court in Albarn held 2 things. It held, first of all, that there's no right of subrogation to money that doesn't cover the medical bills, and 5/6 of that money wasn't for medical bills. And the court also applied the federal anti-lien statute found in Medicaid that says you can't attach property of a Medicaid recipient. And the court held that the 5/6 of that recovery was property. That's a wonderful holding, and it's very intangible and very important. So if you have a plaintiff with a cause of action and part of its medical bills and part of its lost wages and future lost wages and pain and suffering and permanent impairment, the court holds that part of that cause of action is property protected by an anti-lien statute. And I have consistently made the argument that you have a Fifth Amendment protection here, because Fifth Amendment, which involves the federal government encroaching on your right of property. So I continue to make that argument in all these cases. The Sereboff case, The Sereboff law dropped a footnote, footnote 2. The court, you notice that little phrase that was italicized in the ERISA statute, it has to be appropriate equitable relief? Well, the argument was made in the Supreme Court. We made the argument that it might be equitable, but it's not appropriate. What does the word appropriate mean? The Supreme Court says we're not going to address that issue because it wasn't raised at the lower court. And the footnote specifically says the word appropriate might mean the make-whole doctrine. Now, good luck getting a federal court to agree to that, but at least the Supreme Court recognized that. So that continues to be an argument. Even though you might have an equitable claim, it may not be an appropriate claim, and that is recognized in footnote 2 of Sereboff. Once again, Sereboff requires that there be action brought against a specifically identifiable fund and that the contract or the plan language creates a lien. There's lots of case law on that issue, and there's a fair number of cases where the plan loses because it fails in one of those regards. Let me just mention the McVeigh case, Empire Health Choice versus McVeigh. If you're ever involved in a case involving a federal employee, there's FEBA, Federal Employees Health Benefits Act. All federal employees are insured under this health insurance, and you have the same situation there. Here, the Supreme Court held in a 5-4 decision that there is no federal right of reimbursement under FEBA. Now, that's an important decision. And the FEBA bill collectors, I call bill collectors those people like Nginx and Rawlings and attorneys who hold themselves out as subrogation specialists. These entities totally ignore this decision. But if there is a right of reimbursement or subrogation for a federal employee, it has to be found in state law. And it's usually Blue Cross Blue Shield is administered. They can't go to federal court. There's no federal remedy and there's no federal cause of action. And the McVeigh case itself holds that the right has to be controlled by state law. So I just mentioned that so that you're aware of that. There's an anti-annulment provision, not any cases on point that I want to talk about, but the federal statute does require that assets be used for employees only, and I continue to raise that anti-annulment provision. Roman numeral 4 is first dollar priority appropriate relief. We have a favorable decision in Oregon that suggests, my argument has been consistently that Albarn should be utilized in a ERISA setting. No federal court has adopted that argument yet, but a federal district judge in Oregon suggested that as plausibly meritorious, and if we have to go to the next step, he suggested he's going to do that. And so that's also a way to settle cases, or our method of settling if the other side isn't tuned into settling. We're going to pretty soon jump back to this appendix that talks about how to deal with these practically. I think let's just drop over to, there is a federal common law on the make-whole doctrine. It's recognized in 3 circuits, the 6th, the 9th, and the 11th, and it's only on a default basis, so if the plan language specifically negates the make-whole doctrine, the plan language will be upheld. The 8th Circuit has rejected the make-whole doctrine totally, even if it's not there in the plan language negated. You can always, as I had a question at the break, you should always continue to make arguments based on fundamental notions of equity, estoppel, latches. There is a case or two on latches, unclean hands. I think you still have those arguments to make. The word equity is not as friendly the way I would have it be interpreted in the federal courts as elsewhere. Let's see, I think it's page 46. There's 2 ways to apply state law, and I haven't mentioned much about this, but one way you get the application of state law is to avoid or escape preemption to begin with. And in other words, the preemption clause says any and all state laws that relate to an employee benefit plan are preempted. Well, sometimes you have state laws that don't relate to an employee benefit plan. And the best example is your wrongful death cases. There's a split of authority, but the majority view is this. If you have someone who's injured, an employee or a beneficiary under ERISA plan, and they incur some medical bills that are paid by the plan, and then they die, and then there's a wrongful death cause of action against the tortfeasor that caused this accident. Well, under state law everywhere, who does the wrongful death action belong to? It doesn't belong to the deceased, and doesn't belong to his estate, but it belongs to the beneficiaries, the spouse, the children, the family members. Now, the ERISA plans have written into their documents they have the right to all of this money. Those documents are overreaching. They're not controlled by anything. So the ERISA plan, so you have cases where you have a wrongful death and the spouse is awarded $200,000 and the plan has paid $75,000 for medical bills, and it wants $75,000, or it wants all the $200,000. And the plan will assert that because its document, of course, gives it that right. Well, the law of wrongful death, that cause of action belonging to the beneficiaries, has, by the majority view, Fourth Circuit opinion and decisions in Illinois, that law is not preempted. That's not a law that relates to an employee benefit plan. We have similar decision on the laws of minors. If you have a minor, minors are treated a little bit differently in some states. If you have a cause of action in tort for a minor, you have to get it approved by state court, have to get some kind of guardianship set up and an approval. There's case law that says that escapes preemption, and the ERISA plan doesn't have a right to subrogation there. So whatever the scenario is, one of my lines of inquiry is always going to be, do we have an argument here that the state law isn't preempted? And then we come back to the argument that favorable state law may be saved. Takings argument I have there, exciting new cases. Let me just say there's a couple cases in the exciting new cases. Some states have abrogated the collateral source rule for medical malpractice. If you have a client in Pennsylvania, there's some cases out in Pennsylvania and I think also in California. If you have a client who's had a malpractice committed against him or her and has medical and hospital bills of $200,000, when you sue the tortfeasor, you can't collect the $200,000. That's not permitted. That's the collateral source rule is abrogated. Are you at least remotely familiar with that concept? Okay. That sometimes in medical malpractice cases, you can't collect medical bills because the legislatures have come along and protected the insurance companies for doctors by doing that. Well, if there's still this settlement, the plan will try to get that money, even though whatever settlement you have cannot by law include the medical bills. So there are some cases cited in this area that tells us that if the settlement itself doesn't encompass the medical bills, you can't collect, the ERISA plan is not entitled to reimbursement. Now that's a different question than you trying to draft a settlement that says it's not included. That usually doesn't work. In other words, if your client has a right to medical bills, but you draft a settlement that you're going to settle for $25,000 and all that relates to lost wages, the plan's going to assert entitlement in that, and you won't be able to, you might have other ways to defeat it, but that's not necessarily going to work for you there. But if the state law does not allow it, then you have that. All right, let's jump to, there's Appendix 1, a ton of cases upholding the proposition state law applies. Let's jump to Appendix 2. This is where I want to spend some time. My last presentation was focused only on this, and this is how do we, as a lawyer, how do we actually deal with the plan? And so I want to spend some time, I have the general outline, talking about the pressure points. And this really isn't so much a discussion at all of substantive law, but you can do. And I think the very first thing that we need to do is to recognize that this system is entirely skewed against the beneficiary. In other words, the way this system has developed and grown, if you're representing a beneficiary in an ERISA plan, there's very little that you have that's favorable for you. And you have to understand that and recognize that. It's ninth inning, you're down 10 runs, and there's 2 strikes, and there's 2 outs. I mean, that's a given when you talk about ERISA reimbursement situations. Now, there are pressure points. There are a couple, 2 or 3 or 4, very valuable pressure points that you can utilize. And I have utilized these favorably. And you can steer this dispute into your arena by utilizing these pressure points. I will tell you, in the vast majority of cases that come to me, the lawyers have rolled over these pressure points, have misused them, and they're not available. And but the good lawyers know when to slow down and how to draw a dispute into the point of vulnerability for the plan or those people who are running the plan. And so that's what I encourage you to do. And when I get involved, that's what I do. You don't be a bull in a china shop. Understand that we have very few, and I'm going to talk about the pressure points. That's what I'm getting into. The worst scenario, I've never recommended this, but this applies to over 50% of the cases I'm hired on. The worst scenario is the lawyer who has the attitude, let's hurry up and get the money and put it in our trust account, and then we worry about the lien. Well, the problem when you do that, there's lots of problems. But when you do that, if you release the tortfeasor, you and your client have breached the terms of the plan document. So you have put yourself into a breach of the plan document by releasing the tortfeasor. In addition to that, when the money's in the trust fund, you've set yourself up for a lawsuit in federal court for appropriate equitable relief under 502A3 and authorized by Sereboff. You're a sitting duck. So that's a terrible approach. I never recommend it. It shouldn't be done. You should deal with this lien without releasing the tortfeasor. But I have to tell you, probably over 80% of the cases I get are lawyers who've done that. They don't even think about it until after they've got the money in the trust fund and they want to know what to do. Well, I can still try to work with them, and there's still things we can do, but it's far more difficult. Just tune into that. Okay, what I call 3 stages of ERISA lien awareness. I think it's page 65 of your outline, 3 stages. The first stage is as soon as the case walks in the door, before you've invested time and money in this case, you can be very effective in getting a lien reduction. I had a case one time, and here's a standard what I do, is a lawyer down in Missouri. He hired me in a case, and it was one of the cell phone companies, the plan. And I looked at the plan, I wrote him a detailed memo as to why this plan provision is not enforceable, and why there should be no reimbursement allowed. And he turned it over to the bill collector, and the bill collector said everything I said was wrong. I'm used to that. He said, he doesn't know what he's talking about. He's a kook. Everything he says is wrong. And so he said, what do we do now? And I said, well, and the attorney who hired me had just gotten the case. You know, and he's going to get $25,000 from a tortfeasor. And the lien is over $150,000, and the plan wants everything. See? I said, well, we'll just call this guy and tell him that you're not going to take this case. I mean, he won't get paid, the client won't get anything, you're not going to take the case. Or maybe it's $50,000, the tort recovery. So he called him and said, look, you know, I haven't done anything in this case. This is going to go away. You're not going to get anything. That lien, that bill collector went from an absolute refusal to reduce his lien at all to an 80% reduction, just so he could get the 20%. And the lawyer and the client walked away with something. Now, if they know these bill collectors aren't completely stupid, if they know that they're not going to get anything, I mean, that's what they get their money from. If they know there's not going to be anything, then they'll get reasonable and reduce their lien. But they're more reasonable the earlier on, and that's not just the only scenario I know of, depending on where you're at. I have to tell you a worst case scenario. I can't believe I've run into this, but in the last year, I've gotten phone calls or contacts from 3 attorneys in 3 different states with this scenario. They had an accident, they had the chance to hurry up and collect $25,000 from a tortfeasor. The medical bills are over $100,000 in each case. And so this attorney rushed out, sued the tortfeasor or brought a claim against the tortfeasor and got a $25,000 settlement and released the tortfeasor. And now is contacting me because the ERISA plan has taken the position supported by the plan document, which they write. Because you've released the tortfeasor, we don't have to pay the first $25,000 in medical bills, and after those first $25,000 are paid, then we'll pick up and pay what's left. And there's nothing you can do about that. That's a worst case scenario. And has this lawyer helped his client? Absolutely not. He's made life worse for the client. The client doesn't have $25,000 to pay the first $25,000 in medical bills. He's probably got 2/3 of that, right? The lawyer got his fee out of it. 3 different lawyers, 3 different states. In one of the states, it was multiple claims. Lawyers blindly going after, in a greedy fashion, this quick recovery of a minimal amount, and the plan hasn't even paid the bills. See, this settlement was within 2 months of the injury, and none of the plans had paid any of the bills. And now they say, well, we don't have to pay the first $25,000. What can you do for me? Nothing. See? You need to think about that. Should have thought about that earlier. Okay, the next stage of lien awareness, these are arbitrary, but for purposes of presentation, is on the eve of settlement. I get involved in a fair number of these cases. I'm involved in some of these cases right now that are in litigation in federal court. Very effective way to deal with this. You haven't released the tortfeasor, but you've got the possibility of settling this case for for X dollars, and if you pay the lien, there's not enough money to pay everybody. Well, as long as you don't release the tortfeasor, you haven't violated any terms of the plan's conditions. And see, what these bill collectors do is they will coax you along. They'll act like they'll be reasonable later. They won't correspond. They act like they've forgotten about the file. And they want you to release. They want you to get the money and release because they win then, see, because then they win. But if you don't do that, you put their position under a microscope and you take it into court. And their position is, we don't do anything, we don't pay for anything, you collect all the money, and all the money you collect you have to give to us. That's their position. Now, if you haven't released the tortfeasor, that position doesn't look too good in front of a judge. If you release the tortfeasor, you're the bad guy because you've released the tortfeasor and you breached the terms of the plan condition. So here's the procedure that has now never failed me. I wish I could say I'm the author of this procedure. I'm not. I was taught this by a lawyer. Is you bring the plan into your action by an order to show cause. And you tell the plan, every time we've done this, we've persuaded federal judges to issue these show cause orders, even judges that have been ruling for plans. Here's the case where I learned this. We had a medical malpractice case. We had a tort settlement of a lot of money. United Healthcare had paid $1.5 million in medical bills as a result of the malpractice. I can't tell you what the settlement was because it's confidential, but if you were to pay United Healthcare all of its lien, there's not enough money for the lawyer and the client and for everybody to be happy. But we didn't release the tortfeasor. And the attorney that hired me structured this. He says, well, and I'd provide him with a detailed memo, 15 pages long, as to why this lien is not enforceable. Lots of reasons why it's not enforceable. They threw it in the wastebasket. So the lawyer went to the federal judge and had the federal judge issue an order to show cause. If United Healthcare and Ingenex, the bill collector, want to protect its right to a lien, it needs to come into court and pay in the court the amount of the settlement, X dollars. And then we won't release the tortfeasor, and you can pursue the tortfeasor. So if you want, it accommodates everybody's interest, and it makes the ERISA plan pony up money. Within 10 days of the receipt of that order to show cause, United Healthcare gave a complete relinquishment of the lien. Complete relinquishment, and we settled, got the settlement. Case right now, the decision was handed down Friday in Seattle. I've been involved in the litigation. It's ongoing. Don't know what's going to happen next. The lawyer who hired me in Seattle had a client catastrophically injured. Settlement of everything I'm telling you is in a court order that was issued by a judge on Friday, so it's not private. Tort settlement of $605,000 from all the tortfeasors. The guy was on a motorcycle. Medical bills of over $500,000 paid by the plan. We're in state court, whatever that county is, in King County, maybe it's Seattle. We're in state court against the tortfeasor. The lawyer wanted to get the money and disperse it. I said, no, you'll get sued, don't do that. I said, do the order to show cause. We persuaded the state trial judge to enter an order to show cause against the plan. It's Coca-Cola. No, it's Pepsi. I got another one against Coca. This is Pepsi-Cola. Pepsi plan, we entered order to show cause, brought them into state court. As soon as we brought them into state court, they filed a removal to federal court. Okay? I said, I'll draft all of your pleadings. I'll draft your brief in federal court. We filed a motion for remand. We made all the arguments why this wasn't removable. They countered. We filed a reply brief. Judge sat on it a while. Judge sent out an order and said, I want additional briefing on this topic. I want a briefing on the topic of what do the words defendant and defendants mean in the removal statute? Does that apply to a recipient of an order to show cause? I went to work as hard as I could. I found some cases in New York and New Jersey, some federal court cases where plans were brought in on an order to show clause. One was a dissolution case, a marriage case, and they brought a plan in on an order to show clause. And both those judges trial judges held that a recipient of an order to show cause is not a defendant or defendant for purposes of removal and can't remove the case. And there's other cases that helped us. We have specific order to show cause cases. The other side's brief cited Black's Law Dictionary. We got the remand order on Friday, and I can give you a cite to it, or I can give you the copy of the order. We're not done with this litigation because it goes back to state court, but Washington follows the state hold doctrine, or make whole doctrine. So the argument of the make-whole, we don't have to pay the plan anything if the make-whole doctrine is applicable. The plan's also sued us in federal court, so we're still defending that lawsuit, but we have a really good argument there. I've never been involved in, and I did this in Missouri State Court, got one pending in Minnesota, federal court. Never been involved in a case yet where the order to show cause didn't work, because you haven't done anything wrong. You have by not releasing the tortfeasor. Don't release the tortfeasor. Obtaining documents, page 66. There's a procedure under ERISA, and there's an article, this is Appendix 4. There's a procedure under ERISA to obtain documents. What I run into, let's talk about this. Lawyer after lawyer that I deal with gets involved with this ugly letter writing contest with the bill collectors, with Nginx, with Rawlings, with these attorneys, with paralegals, with people who say they're subrogation specialists, and these subrogation specialists say, well, we need proof of your self-funded status, and they'll provide them documents. The documents that these bill collectors provide, I've never once seen to be accurate. Either they're not at the time of the injury, or they don't even relate to the plan. Never once have these documents, if you've been involved in a letter writing exchange with these bill collectors, they're always self-serving. In the case, in February of this year, I got hired in a case in St. Louis, and I didn't figure this out. Marilyn, my assistant, figured it out because she files these documents. The bill collector sent the lawyer in St. Louis 3 different documents, sent him a summary plan description, and 2 different Form 5500s. The Form 5500 is what's filed with the Department of Labor. Well, Marilyn came to me and said, you know, each one of these documents is for a different plan. It's one of these, you know, it's like Pepsi and Coca-Cola and Sprint and Nextel. They got different plans for different states, and this bill collector found the 3 best documents from 3 different plans altogether. Now, we have the problem of figuring out which plan our guy is insured under, but he's not insured under 3 plans. He's only insured under 1 plan. And I mean, that's just a typical example. So my advice is to ignore any exchanges with the bill collectors. Don't get in a urinating contest with a skunk. And utilize the procedure in ERISA to allow you to serve a written request for plan documents, and have a model form there Marilyn and I have prepared. Because if the plan administrator doesn't comply, it's subject to a penalty of up to $110 per day for each day of noncompliance. And there are courts that have held that penalty on a per document basis. And there's lots of documents that they may not comply with. Yes?
When you say these bill collectors, do you mean like Fair Debt Collection Practices Act, they hire an outsider to collect their ERISA claim? Or are they actually an in-house employee of the employee's boss, so to speak?
Well, they come in all shapes and sizes, and they're not really bound by the Fair Debt Collection Practices Act because it's a federal, ERISA's federal. But a couple of them are Primax, Healthcare Recoveries, Nginx. Are any of these names ringing a bell to anybody?
So they assigned their
right, they're the agent.
rights under law to a third party?
They will, well, you may not, it's going to be hard finding out what they've done, but they will be the agent for collection. They will represent themselves as the agent for collection for the plan administrator, or the claims administrator.
Documents that show, I mean,
Yes.
is that equitable relief assignable?
Well, the lawsuit, when it's filed, is brought in the name of the plan. So if they go to court, the lawsuit's brought in the name of the plan. Okay. Right. I mean, what I'm saying is there's an army of so-called subrogation professionals that are out there for you to skirmish with, and they will drag you down. And I don't skirmish with them. I mean, sometimes you have to because they're the only person that you can send a negotiation to. But I invoke the request on the plan administrator because that imposes a personal penalty on the plan administrator. Now, the federal statute says that request has to be made by the plan participant or beneficiary, and we always do that. A lot of attorneys try to invoke that by making the request over the attorney's name, and I'm not going to tell you that doesn't work because there's some cases that uphold that. But it's like when I first started practicing law and I kind of learned the wrong way, you know. I think I had a case where I answered interrogatories from my client. Oh, you don't answer, the client answers interrogatories, you know. Same thing here. The statute says a plan participant is the employee, a plan beneficiary is a dependent. So if the father's the employee, he's a participant, the son or the wife would be the beneficiary. Both of them are given the right to request these documents. And you need to serve it on the plan administrator, and you may not know that, it may be hard to find, but that's a little bit easier to find than everything else. So that should be in the plan, the summary plan description. And also you should go to your HR department, Human Resources Department of where they work to find out. In addition to that, let me say this, that the ERISA statute recognizes these entities, a plan sponsor. The plan sponsor is always the employer, okay, so it's whoever the employer is. Then you have to designate a plan administrator. If there is no designation of a plan administrator, the ERISA statute defaults to the plan sponsor. So the plan sponsor, so almost always these requests are served on the employer, who is either the plan administrator, either by default or directly. Now these plan administrators will hire claims administrators or TPA or third-party administrators, which just confuses everything. And these administrators who they hire to handle claims are a lot of times the one that are pursuing the reimbursement claims. And they have a contract with the plan sponsor, and that contract is giving them these reimbursement recoveries. See, these recoveries are contracted away to these insurers and to the administrators, all or part. They get a real healthy percentage, or they get, and if there's a stop loss coverage, stop loss is like a deductible. Anytime you have it depends on what you have, but if you have the smaller the plan, the more likely you have a stop loss, a smaller deductible. If you have a small employer, they'll have a stop loss policy that may kick in after payment of the first $10,000 in medical bills. Some of your stop loss policies kick in after $50,000. So if you have a catastrophic loss and there's $200,000 in medical bills, the first 50 is paid by the self-funded plan and the other 150 is paid by the stop loss carrier. And I've looked at the stop loss contracts, and the stop loss contracts mandate the plan administrator has to cooperate and give them the reimbursement claim. It's just like the $250 deductible and the $10,000 damage to your car. So let's send that certified mail. I send it in a plain envelope, and I think it's like a nuclear missile. The wonderful thing, it has a couple, if you follow the statute the way it's worded, and it's all laid out for you in the article, a lot of times you get it's not a poison pen letter from a lawyer who's had it up to here with the bill collector. It's just this innocent letter from the employee wanting these documents. I send them to the attorney, though. I have them sent to the attorney. And in one case I'm involved in litigation with right now, we ask for all kinds of documents. Marilyn helps me put this together to be educated to ask for these documents. And, you know, I think we asked for a total, if they're all there, like, 70 documents. And the plan administrator wrote back and says, you asked for a lot of documents, but here all you really didn't know are these 4 documents, and here's one of them you didn't ask for, and it was for 2008 SPD, and the accident was 2006, and the law says you have to apply the one in 2000. You need this one, they wanted to, and they gave us 2 we asked for, and the other one they said you need, we're not going to give to you is confidential. And there's no confidentiality under ERISA. And so now we're in federal court, and we've got this suit, we have this claim for the penalties, and we're showing their non-compliance with that. The other, Marilyn thinks, I don't think this has ever really gotten much mileage, but she says if the employer really knows about how serious the case is, the employer might cave in and pay the bills himself. And I've never seen that happen, but by serving these documents on the plan administrator, who is usually the employer, as opposed to the claims administrator, at least you know the employer knows there's a problem here and the employee is not going to be given enough money to go around. So there's a lot of reasons to do it that way, plus you create that cause of action. So that's one of your pressure points, is making this proper request for documents. Other strategies, the various entities and roles. These claims administrators, lawyers will always, and these are sad cases. The Schenck case is a sad case. There are dozens of cases like the Schenck case where the result ended up just the way it did in court, and there was nothing for the person who's left out. Nothing. But you try to sell your sympathy to these bill collectors aren't sympathetic because it's their money. They've been assigned that money. And so the plan administrator might be more sympathetic, but I'm not saying not to do that, but just understand they're not your friend. They're not going to do it. I learned this because I read it from a letter from a bill collector to an attorney. He says you're threatening all these penalties again. He says we're not subject to penalties. That's absolutely right. There's no ramification. There's no penalty that can be imposed against the bill collector who misrepresents what the document says, who acts bad and does anything. There's no, the only ramification penalty you have is against the plan administrator, and the only way you get the plan administrator on the hook is by serving that request for documents. Let's see, no applicable state law. Okay, itemized billing, let me just mention that quickly. I found that these bill collectors tend to lump everything in there. So if you have somebody's in an accident and they have $80,000 in medical bills, and they also happen to have a tonsillectomy totally unrelated to the accident, and that costs $15,000, they're going to want to be paid $95,000. So you need to go back if you can and get a hold of those bills and make sure every bill that they're seeking, I mean, they tend to take every bill that's in that person's name and get reimbursed for that, even though some of those bills may not be related to the accident. Don't ask, don't tell. Don't lie, don't misrepresent. Obey the plan document, obey the law. But that doesn't mean that you have to volunteer information. And I've seen many lawyers volunteer information that doesn't need to be volunteered. And I've seen lawyers very effectively settle or deal with a settlement for $25,000 from a tortfeasor, resolve that lien. The plan is completely out of the picture. They signed off on it. And then that lawyer turns around and collects underinsured motorist coverage on one or two different policies that they're stacking. Bill collector never asked about it. He never volunteered it. They don't know about it. They've signed off on it. Bill collectors and the attorneys who are bill collectors aren't tort lawyers. They don't know the law like you know the law. Don't educate them. I've seen that scenario over and over again. Now what I get, I mean what lawyers do, and it's part of our training I think, is I'll get a plaintiff's lawyer come to me in a very methodical fashion and say, okay, here's the case, here's the facts, here's the accident, and it looks like we're gonna get $25,000 here, we got a chance for underinsured motorist coverage, another 100 here, we're in a jurisdiction, you apply stacking, we get another 100 here, and so here's all my sources of recovery, and we still fall short because the medical bills are $500,000. So they make this full report. That's like the first thing they tell me. And that's good. That's what I want to know. And I'm on their side, and I'm not going to use that to their disadvantage. But I've also seen these same lawyers engage in that conversation with the bill collector before they've talked to me and tell this bill collector who may not know about underinsured motorist coverage and may not know about stacking, don't educate them. I guarantee you they're not going to educate you on anything to be helpful to your client. So don't ask, mainly don't tell. Don't lie, don't misrepresent, comply with all the terms of the plan document. Don't do anything unethical, but you don't have to volunteer information. The Department of Labor will engage in audits. An employee or participant or beneficiary has the right to ask for an audit. Plan administrators don't like going through audits. I've never actually requested an audit or had a client request a client or had a lawyer prepare a document for the person to request a client. But we've threatened to do that every now and then, and we've gotten a little bit of movement, not much. It's never been something, but I've never actually requested the audit. I also want to point out, and I've attached the appendix, President Obama issued about a year ago, his directive is attached as Appendix 3, and this reverses the Bush administration. Remember my general discussion how state law protects consumers? And then to avoid the operation of state law, you claim there's federal preemption, and federal preemption means not that the Congress has looked at this in a reasonable fashion, but it's whatever the business wants. Well, his proclamation directs all agencies to do the reverse of that and not engage in federal preemption and not assert there's federal preemption, and wherever possible, reimpose the protective provisions of state law, and that includes the Department of Labor, to whom these ERISA plans report. So that's one of the tools in your arsenal. Let me take some questions. I know I've had some, but I know some of you may have some more, so let me take some questions. Okay.
If there is stop loss coverage, state law should apply?
That's always been my position, and there's some case law that supports that. So if you have $100,000 paid in medical bills and the first $50,000 was paid by the plan and the other $50,000 is paid by a stop loss carrier, my position has always been you apply state law to the $50,000 for the stop-loss carrier, because that's where it's gonna go. If that money is recovered, it's paid back to the stop-loss carrier, because that's contractually required. Now, that doesn't mean to give up on the first $50,000. We have other arguments that will deal with that, try to apply the Albarn method, make sure the plan language is there. There's other things we can do to contest that, but that's always been my position. Wherever money is paid by an insurer and not purely out of the self-funded part of the plan, you apply state law. And that's unfortunately where you have that some adverse case law that says a self-funded plan doesn't lose its status as a self-funded plan by merely having some insurance. But when I started talking about that, that was the majority rule. Now that's a minority rule, and there's been a lot more cases in Appendix 1 that say you apply state law to insurance on the risk.
How do you deal with attorney's fees and court costs? You know, we've had cases over the years where the ERISA plan takes the position, we don't have to pay a proportionate share of attorney's fees, we don't have to pay a proportionate share of the costs. To me, that's a violation of equitable principles. They're getting something for nothing. It just doesn't seem to be right. But a lot of jurisdictions have held they don't have to.
Right. The plan document will say that they're not obliged to pay any attorney's fees. Right. And under federal preemption, that controls. Let me just say this, and this is not a complete answer. I agree with you 100%. It's not fair, and it shouldn't, but that's what's, first of all, don't release the tortfeasor, and you can deal with that much more effectively. But if you've already, okay. Here, let me just say this. There is an Eighth Circuit case. It's not in my materials, but I can send it to you if you send me an email. There is an Eighth Circuit case that says you're entitled to your attorney's fees, applying pure federal law. And that's kind of a hidden case, but it's out there. Now, unfortunately, that case doesn't say you're entitled to the contingent fee that you have, but at least it says you're entitled to your attorney's fees. And I can give you the cite to that case. Eighth Circuit is extremely harsh, as you might know. It just about everywhere you can rule against the beneficiary on issues the Eighth Circuit has. But there is this one case, so you have that. There is a body of federal common law, just like on the make-whole doctrine, there's a body of federal law. Getting attorney's fees is called the common fund doctrine. The common fund doctrine is if something happens to everybody in this room and we're all entitled to collect damages and we don't file a lawsuit, but I file a lawsuit for everybody and I collect a pot of money for us all, and I'm going to give you your share, everybody should pay the attorney's fee, a share of that attorney's fee. So somebody who collects a fund in common for multiple recipients, all the multiple recipients should share in the attorney's fees. That's called the common fund doctrine. And in the area of subrogation, there are many, many state court opinions. We have one in South Dakota, which requires a subrogated insurer pay its share of the attorney's fees. And so you would deduct 1/3, actually they have whatever it is. And that's called the common fund doctrine. And so that same principle, so there is a federal common law on the common fund doctrine. But again, it's more or less on a default basis. If the plan negates that, then it doesn't apply in most situations. Yeah, it's horrible. I mean, yeah. Okay. Other questions? Other questions?
Is there a statute of limitations that would apply to their claim at all?
Okay, this is a great question, and there's not. Once again, it's not an easy answer. I know of an attorney, I won't tell you where or his name, he's sitting on $1 million waiting for statute of limitations to run out so he can distribute it. And I know of another attorney, he's sitting on $200,000 waiting for the statute of limitations. So when is it safe to distribute the money? There is no federal statute of limitations. So you don't find one in the ERISA statutes. And so what federal courts do is they borrow state law. Okay, the plan document may talk about it, so the plan may have a statute of limitations, but there probably isn't one for this. There probably isn't one for this. And so you apply state law. Which law of the state do you apply? And there's cases, there's law review articles on this. It's not an easy answer, but you would hopefully, I mean, one possible answer is if you're in North Dakota, you look at the North Dakota statute of limitations for an action on a contract, and you would apply that. Unfortunately, I mean, I would probably tell you that doesn't start to run until the money is there, not probably from when the accident occurred, but probably when you settled and released the tortfeasor. That's probably when you would start it to run.
So responding to Al's question, in malpractice cases, we've had some success because most of the plans say that if the plan administrator agrees to pay for fees and costs, they'll do it. During the course of the litigation, to send the plan administrator things like the defense expert opinions, just so they know that there's risk, that they may not recover anything at all. And that's worked more than half of the time.
Well, we've had good success with Blue Cross Blue Shield of North Dakota, where subrogation people generally have been pretty good, at least in our malpractice cases, and so we've been able to get them to agree pro rata share, and they take on administrative responsibility for some of the ERISA plans. And so we've had some luck with Minnesota as well, we're getting a little better over there. But it depends on the plan. If it's a new plan you're not used to, you have to take, I agree with you 100%. If you don't deal with it up front, I write them a letter right away and say, are you going to pay a proportion share of fees? And if they say no, I'll say, well, we don't have any interest in funding this malpractice case. Go find someone to do it.
Right. I work closely with attorneys on the other side, and there's some I really respect, and he tells me that if that letter comes early, they'll respect it. But if you've already invested lots of time and money in it, they're not going to believe you when you say, we're not interested in it anymore.
Right,
So,
exactly.
yeah.
You gotta do it right away.
Yeah.
I have a question here. I've run across a situation where if the plan knows that there was like a car accident involved, before they pay any benefits, they will send out the documents to the person and say, you have to sign this document or we're not gonna pay you. By signing those documents, are the plan participants giving up some of these arguments you talked about that exist under the plan? I mean, can they waive their ERISA rights? Some of the things that are favorable to them by signing the document saying, when I recover, I will repay you?
Right. The question is about, first of all, most plan documents today have that in there, that they can require the participant to sign a document of affirmation, if you will, that they will, before they pay the medical bills, pursue that.
The plan, the last time I saw it, the plan itself excluded payments if there was a third party responsible.
Right.
So they said, since the plan excludes payments, we're not gonna pay you unless you agree to sign this.
Right. I mean, and that's what I'm talking about. They will try to phrase their coverage as alternative coverage. We only pay if no third. The problem, you've asked questions that I'm not going to be able to answer quickly. Okay, so let me get sidetracked on that first, on that issue, and that is, if the plan has a document, has language that says this coverage, this health insurance coverage, is only there if somebody doesn't else pay. Well, that's problematic, because most of the time you're not going to know whether or not you're going to have a recovery until years later. And so in the meantime, the bills have to be paid. And now, is that health insurer or is that plan going to not pay those bills? If you can trigger state law, but sometimes it's there and sometimes it isn't, there are mandated requirements by the NAIC, National Association of Insurance Commissioners, that say medical bills have to be paid within a certain period of time. 30 days, 60 days, 90 days. So there's usually state law protections mandating that. So if a plan is acting so far out of the orbit that it's not paying those, it's going to be in violation of those provisions, which isn't good, but it's also kind of in violation of its agreement with the employer. So it runs into some kind of jeopardy in well, maybe this isn't a good idea to use this strategy. But they do say that, and there are situations where the plan has the right not to pay the bills. That's why I say in those cases where these lawyers went out and settled for $25,000 right away, the language of the plan supported them 100%. So there's issues with that, and I don't have an answer for that except to say that in most cases that I run into, you know, unless you got Johnny on the spot that goes out and gets the settlement right away, that really isn't an issue. Now, as to the agreement that the guy has to sign, that complicates things. But if you don't, once again, the preferred strategy is not to, let's get a settlement and then worry about the lien. If you don't release the tortfeasor, I think you can take care of all the issues in a satisfactory way. And the earlier you take a look at it, the better. But yes, I mean, that's part of the unfairness here. There's lots of things I don't have good answers for, favorable answers.
Okay.
All right. Thank you. I'm done now.
Yeah,